Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you. And this is the first of a lecture series on contracts. The first one here is going to cover the key concepts and resources in contract law. And we're going to provide you with an overview of essential concepts and resources in contract law, including some foundational principles, case law, statutory frameworks, and some research tools to help you understand and also be able to apply it. Sorry. This is our agenda overview, some foundational information, knowing how case law and judicial decisions fit into contract law. The restatement of contracts is covered, as well as some of the Uniform Commercial Code, and some consumer protection and sales law, as well as issues involving electronic transactions, e-commerce, and the like. And, of course, as I've already mentioned, you'll have some new information on legal research resources, as well as some practical application. So, the foundations. We'll now cover an overview of its historical development and categories of contract law. So, general overview, the foundations of contract law. They're established, the contract law is what establishes rules for legally binding agreements between parties across history. And historically, contract law evolved from early customs and now have become modern statutory and case law frameworks. In contemporary contract law, where our modern contract law will address the current commercial and technological challenges in agreements, because a lot has changed over time. Some categories of contract law. First of all, contract law is something found in both common law and statutory law. So the common law contracts they're based on judicial decisions and precedents, and these govern agreements. Also included in contract law as a category are statutory contract law, the Uniform Commercial Code, UCC we'll call it, is a typical reference to it. It standardizes the commercial transactions and contract rules. So the role of precedents, judges' decisions create precedents for future judges to follow, and creates legal concept of stare decisis, which is Latin for stand by the thing decided, or what is already decided. And setting and following some precedents is a foundation of common law. Case law is also applicable, and that is obviously it's defined as the case law created through judge-made decisions that interpret different laws. And the sources of case law are deriving from common law and constitutions and statutes, administrative law, and procedural rules. We have authority types. In legal research and writing courses, for example, you learn about mandatory and persuasive authority. And mandatory authority is that those cases, the decisions, the court decisions that are precedents that the courts must follow in their decisions. Now, there are jurisdictional issues wrapped around that, really short statement, but this is just getting us introduced to where to find it. And then there's persuasive authority, and that means, well, they can follow it, the judge can follow it, and if they want, but it's not mandatory. And there's jurisdictional components to that. Obviously, if something comes from a different jurisdiction than the one that you're arguing a claim in, it may not be, it may look like it's from your state, like I'm in Florida, but I might not be in the same district. So if I'm in a different district and I'm plugging precedent from another district, it would only be persuasive authority. If it were in the Florida Supreme Court, however, this is really easy. Keep this simple. If it's in your state Supreme Court, it's your highest court, it's going to be mandatory all over the state. So we have to do a little bit of terminology, actually kind of sort of a lot. In case you don't have a whole lot of legal experience, this will be valuable to you. In the court process, in contract cases, there are different roles of different parties. For example, the plaintiff is the person wronged by the wronged or injured, the party who will initiate the lawsuit by filing a complaint. The defendant's response is also called an answer, and the defendant will respond to the complaint of the plaintiff. The case identification, they're identified by a court docket number, and then proceedings will start in trial court. And the appeals process is where the losing party can challenge the trial court decision and appeal it to a higher court. Now, in judicial decisions, there are some important elements of those to understand and be familiar with, like judicial reasoning, and that is the court's decision. It's always based on logical reasoning that's applied the facts and the relevant laws, and that's how they've reached a conclusion. Dicta are statements in a court opinion that are essential to the decision and do not form binding precedent. You see this in cases, and it can be helpful, but it's not going to be precedent that has to be held to. A holding is the binding legal principle or rule established by the court's decision in a case. And then case summaries provide concise overviews of the holding and procedural history, while headnotes summarize legal points. I would be careful the way I've worded that. The summaries are available in the cases when they start out, but that's all editorial, all right? And so are the headnotes. They're all editorial. So we need to be very careful, like using artificial intelligence. We need to make sure it's correct by reading the case anyway. So we're not going to rely on the synopsis that's contained in published cases or the headnotes, but they're going to be great directionals as to whether we're in the right place. The restatements of contracts is really an important to know when you're working with contract law. The purpose of and structure of the restatements is they clarify and organize contract law principles for legal reference and education. Now, restatements are like in tort law, we rely a great deal on the restatements. Although they're secondary authority, they have a wealth of information on what is mandatory. So know that this is a very valuable tool because of, like torts, contracts has the common law, heavily emphasized in contract law. As such, having the restatement is a way of being able to find the black letter law there, because it'll be widely accepted legal rules and principles for consistent application. They're published by the ALI, the American Law Institute, and it's the authoritative publisher. It's divided into chapters and subsections, so it's clear, detailed, organized in such a way that you can locate the information the law you're looking for. ALI also includes commentary, illustrations, and authority status. So each section of the restatement of contracts is followed by comments from the ALI and provides some illustrations that help the reader clarify legal concepts. Like I said earlier, it's persuasive authority, so it's non-binding authorities. They don't carry the weight of case law or statutes. They're not mandatory authority at all, but they are persuasive. The Restatement of Contracts has various editions, just like your textbooks in school. They seem to change to a new edition each year, hopefully not that frequently. But the point is that there'll be different editions. They're divided into chapters. There's 16 general chapters that organize all the contract rules, and it's a very systematic organization. The structure of the chapters they present a general rule of law, followed by detailed commentary, and practical examples. The Uniform Commercial Code, which we refer to as the UCC, is essential to discover early in the learning of contracts, because it is part of statutory law. So UCC, Uniform Commercial Code, governs commercial transactions across the United States. It is a standardized way of handling business law matters. It was created by the National Conference of Commissioners on Uniform State Laws to unify commercial laws across the country. And the current UCC has 11 articles and has been adopted wholly or partly by all 50 states. What we want to make sure you understand is that this is a common set of principles that can be adopted in all states, but states do enact their own UCC, which may differ in some slight ways, maybe due to conflicts in the law of the UCC versus the state. So just know that it's not like the same book would be sitting on the same everybody's book with labeled UCC in California, Arizona, and Florida are all going to look alike. They're not, because of the legislative action process. The role in commercial contract law and modification of law in the area under the UCC, the source of it acts as a primary source governing commercial contract law and business agreements. It adapts and modifies common law principles so that modern business and commercial needs can be met. And like I said earlier, it's commonly known as the UCC, but it's standardization of commercial contracts across jurisdictions. All right, formal documents are part of the contract world, and so we're going to know that complete formal documents, when you're writing formal documents, you need to be sure to use complete proper names. So use that carefully, be detailed. Now, if you have a shorthand reference, like we just were talking about the Uniform Commercial Code, it's the Uniform Commercial Code, and in parentheses, we can put the shorthand reference of UCC. And so the first introduction you would include, if you're citing, I guess this is a good way to, if you're writing the law, writing about the law in a motion or in an essay, whatever it is, you can use the shorthand. The first time you use the complete proper name of the, for example, Uniform Commercial Code, then you can, in parentheses, put the UCC, and then from there on after, typically you can stay on just UCC. But that's just a formality of writing. Next, we'll look at the laws governing domestic sales and exceptions, application of the common law versus UCC in transactions, consumer-based laws, and legislative protections. So the law of sales in Article 2 governs the law of domestic sales in the United States. And some form of the UCC applies when a seller sells goods to a buyer. And an exception is, in the state of Louisiana, its Civil Code of Sales has been revised to parallel Article 2, and it's been divided into 7 parts. Well, when you're asking the question, when you're researching or trying to come up with a legal conclusion or opinion about a contract dispute, it's looking to which law is going to apply. Would we apply the common law or the uniform commercial law when we're dealing with transactions? Well, common law of contracts will apply to transactions that don't involve a sale of goods, such as a service or sales between non-merchants. For example, one student selling a used textbook to another student, or a person hiring someone to paint a building. UCC Article 2, on the other hand, applies to transactions involving the sale of goods and merchants. So purchasing a new computer from a retailer would be the type of situation where you would make your legal conclusions from the UCC. So that's an important distinction to make when you are analyzing a problem or a scenario, is that whether it's for the sale of goods and involving merchants, it would be UCC Article 2. If it's a transaction of services or sales between non-merchants, like my textbook example, and excluding goods sales, we would be dealing with under the common law. All right. There are consumer-based laws that protect the public. So if you think about what we were just covering, those are the laws that cover disputes, but there are also laws that are specifically made to protect the public. Congress and states have passed numerous legislative protections. So again, these are legislation. Magnuson-Moss Warranty Act, for example, was passed by Congress. It applies to warranties for transactions for products used by households, families, or individuals. Either a full warranty or a limited warranty. And states have a myriad of consumer-based laws and a common thread is intent to protect the consumers from unscrupulous merchants or manufacturers. An example of a warranty act, something under the Magnuson-Moss, is the limit laws for vehicle purchases, and most consumer purchases involve contracts of some kind. We'll look at some key statutes now for electronic transactions involving the fluidity of e-commerce law and practitioner responsibilities. So Uniform Electronic Transactions Act, or EUTA, it's the electronic document equivalent to original paper counterpart. So electronic signature, and we also have the electronic signatures in Global and National Commerce Act, which is e-sign, nicknamed e-sign. It's a federal law that allows e-contracts, e-signatures, and e-transactions, and provides a mechanism for collecting and storing e-documents. The Uniform Computer Information Transactions Act, UCITA, addresses electronic and internet transactions, and it's only adopted by Maryland and Virginia to date. Law of e-commerce is fluid. It's constantly changing, and your role is to find answers to the inevitable questions that will arise. So in looking for answers, we use legal treatises and hornbooks as a source of legal information and law, also law review journals and state bar journals, encyclopedias, form books, and state practice series. Internet sites and online legal research tools also come into play with our legal research for contract law. So when we begin our journey into legal treatises and hornbooks, or into the research process, this is a good starting point using legal treatises and hornbooks. Legal Treatise is a scholarly legal publication devoted to study and interpretation of an area of law. And those that are most frequently cited by judges is Corbin on contracts, and Samuel Wilson's A Treatise on the Law of Contracts. And Corbin can be found online on LexisNexis, and Williston can be found online on Westlaw. We also can consult hornbook treatises, which are single volume treatises that are often used in law school setting. Offers some details, but more condensed version than a legal treatise does. The leading hornbook for contracts is Contracts, the 7th edition. It's Thomson Reuters West publication. Notable hornbooks on the UCC and sales include White and Summers Hornbook on the Uniform Commercial Code, and also a user-friendly Nutshell series is published by Thomson West. And it's not to be used in research of a contract case, simply a supplement for understanding general legal concepts. Next, law review journals and state bar journals, another excellent getting started sources. Law review journals are published by law schools. They have articles from noted scholars and professors on a myriad of topics, and they're extremely well researched. Case note sections are authored by students, and they offer extensive source material in the footnote section. And then state bar journals provide articles on state-specific issues written by attorneys and professors, and they're less detailed but discuss trends and hot topics in law. They can be helpful for current topical issues in your jurisdiction. Encyclopedias, form books, and state practice series are another getting started source. American encyclopedias, American Jurisprudence is a comprehensive encyclopedia and has excellent detailed overviews of every area of the law. And there are state practice specific and subject specific versions also available. And the state practice series, such as form books, contain forms to assist in drafting documents. They provide a guidance on the law of the state and how to prepare documents relating to the transaction. And they're available for most states, and forms should be modified, of course, for this client's specific needs. But they are great guidance for legal drafting. Internet sites and online legal research tools. Fee-based legal research sites like Westlaw and LexisNexis are available. They're fee-based, but we can get less expensive services from FastCase, public.casemakerlegal.net, casetext.com, and scholar.google.com. Free sites would be FindLaw, Justia, ILRG, All Law, and UpCounsel. And law school sites are another excellent source. law.cornell.edu is one that I would recommend. And then, of course, general search engines like Google, Yahoo, and Bing. Federal court sites also have some research opportunities online. And you could go to your state courts. If you go to, what is it? statecourts.state, and then you put an abbreviation of your state, .us. I think that will take you to state court sites. So federal statutes, congress.gov, house.gov, and govinfo.gov are good helpful tools. So how about, what is it about we need to know about applying our contract law in real life? We would apply it in real life, understanding applicable laws. We know the applicable laws, and we're able to be informed. Well, all this information and the things that you can find from the locations of research are important startings to your understanding of contract law. What laws may apply, where to find them, in the chapters will all, and in this, in the next, we put it this way, the next lectures in this series will keep building on and give a complete picture of the understanding of the law of contracts. So this is just the beginning. So what you might think about in concluding this is, some little topics for your own skills improvement, like reflect on which contract law concepts are most challenging to you and where you might want to further review for better understanding. Evaluate something like the UCITA. What are your thoughts on the Uniform Commercial Information Transactions Act and its impact on contract law? And identify key skills from each chapter or each lecture as you go along, and write down some actionable steps to help you improve your understanding. So a brief conclusion. Foundational concepts are core contract principles that establish the basis for understanding legal arguments very clearly and effectively. The importance of case law, where we're provided with practical examples and judicial interpretations of contract law. And then there's statutory frameworks to keep in mind, and how those regulate contracts and provide frameworks for enforcement and compliance. Some key resources utilizing our authoritative resources is a good start, but you can also be confident in your application of contract law principles when you use the key resources. So this concludes this first of the lectures on contracts. Thank you. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.